Hi guys, it's Kathy. I hope you're doing well. Weller than me, I hope. Everything crashed this morning. Everything I had set up ready for this stream, gone. But it's okay. We adjusted. We overcame. We adapted. I mean, there's plenty of court. Right? Plenty of court. So we're going to be fine. We're going to 46th easy for you to say. The 46th district in Michigan. But we're going back in time. We're going 2 years ago. Unmute. Court. Look, there's court. And now we just have to make sure you have sound. No one's speaking yet, but you do have sound. Innocent, my foot. You're not innocent.
Yes, that's all the swear tos I have, correct.
Okay. All right, so I think we'll have, who's coming in first, Paramore? Oh, Anderson, okay.
Oh no, there's a bar of fire? Hi, Terry. Oh no. All that alcohol is gonna burn. Burn.
Oh, jeez.
All right, I believe, is this Mr. Anderson, sir?
Yes, ma'am.
Okay.
Mr.
All right, so this is going to be
Anderson.
case number 21S920, people of the state of Michigan versus Sherman Lewis Anderson.
Guys, Martha's here. You better behave.
Yes, I'm sorry. Good afternoon, Your Honor. Christopher Shepke, for behalf of my client.
Hey, you better not yell like that. Martha's here. You better behave, Christopher. Can't read that, sir.
Said to the matter being heard via Zoom. As to arraignment, we waive formal reading. My client stands muted. He has been advised of his constitutional rights. We are prepared to proceed. Thank you, Judge.
Thank you, Mr. Shemke. And sir, tell us your name for the record.
Sure, Sherman Anderson,
And what's your address, sir?
18917 Wooding Ave, Detroit, Michigan, 42221.
And do you have a phone number?
Yeah.
See, Amy, you don't understand. Martha doesn't care. Look, just live your life. She's not going to yell at you. She's not going to tell you what to do. She doesn't care. Not that she doesn't care. What I mean is, Martha doesn't get pinned down by stupid rules that people have for no reason. If she was in charge, we would be able to live our lives happily. Like, stress-free. Like, no issues, none. Just live your life.
Yeah, 734-765-8171.
And do you have an email address?
Not one that I use particularly
Okay,
unless it's work.
that's fine. All right, you're here for arraignment, sir, on this charge of carrying a concealed weapon. It's a maximum penalty of up to 5 years in prison. It is a felony charge. The maximum fine could be up to $2,500. So you are waiving the formal reading of that complaint and standing a mute. So you understand the charge?
Yes.
All right, so the court's going to enter a not guilty plea on your behalf and advise you that you certainly have a right to remain silent as to anything involving this charge. Anything that you say orally or in writing could be held against you in court. You do have the right to have an attorney representing you at all phases of these proceedings, and especially during any questioning. If you cannot afford an attorney, one would be appointed to you at court expense, at public expense. All right. So you wish to have an attorney to represent you at this time.
Yeah. Yes.
All right. Let me get just a little bit of information on you, sir. Were you working before you picked up this charge?
Yes.
All right. And you planning on hiring your own lawyer, or would you like the court to appoint one for you?
I'm not sure, to be honest.
Okay, well, let's find out. Where do you work?
Sure, Family Dollar, Dollar Tree.
Family Dollar, and how much do you make there?
85,000 annual.
$85,000 a year?
$85,000 a year, Judge. Yes, sir.
Okay, and what kind of bills do you have?
House paid off, car
Mortgage,
paid off.
I have a
Tell me,
4-year-old son.
how much is your mortgage? How much is your mortgage? Let's start one by one.
Sure, 1,000.
$1,000 a month?
Yes,
Okay, and then do you have insurance on your house?
yes.
And how much do you
300.
pay for that? Or is that in your mortgage?
Kelly, thank you so
300
much for the
separate.
cheer, the super cheer.
Okay, all right. Do you have a utility bills?
Yes.
How much?
Uh,
Break them down. How much for your
well,
DTE?
Sure, PT 350.
Okay.
Water,
Do you have
water.
do you have
75.
consumers? Wait a minute, which
No,
one is 370?
DTE.
DTE is 350. What else did you say? I didn't hear you.
And then I said Detroit water and sewage, 75. Cable communications, 300. Cell phone for myself, my wife, and mother-in-law. I believe it's about 400, 450.
What bills do you pay
My
regularly?
son's tuition, he's autistic, and so he's at U of M early education. That's 1,000 a month. And babysitting
have
on the days that he's not at school.
I couldn't hear that last part.
Sorry, and babysitting the days that he's not at school. He's in school Monday, Wednesday, and Friday. And so Tuesday and Thursday, a babysitter is paid for child.
Well, how much is that?
That's just 300 for the 2 days, so 150 a day. And I also pay for.
So
my
how
mother's
much is
home.
that? How much is that per month? Do you pay in babysitting? I'm doing this by month. So you're telling me
sorry.
it's $1,000
Sure.
a month for his tuition?
Correct.
How much is it monthly for his civic services?
Well, that's split between me and my wife. 600 for myself and 600 for her.
Okay, so you pay 600, okay? Do you have credit cards?
Yes.
How much in credit card debt do you pay monthly?
Not much, no more than 400 a month.
Okay, and what about
I have my
car
mother's
note?
home care.
You have what?
Sorry, my mother's home care. I pay
Your
for
mother's
a
home
considerable.
care. What is your mother's home care?
She has MS, and so currently she's not mobile. She's bedridden, and so I pay someone to
Okay.
come there during the days at work.
How much do you pay for that monthly?
That's $480 a month, or excuse me, $480 a week.
So, okay, so 480, let's say times a 4-week month, that'll give you $1,920.
Yes, and that's about.
You
that's
pay,
about it.
do you have a car note?
No,
What about car insurance?
car insurance. Yes, that's
How
about
much
150.
150 a month?
Yes.
Okay, so I've got a mortgage at $1,000 a month. I've got your insurance for the house at $300 a month. I've got DTE 350. I've got $75 water bill per month. I've got a cable bill at $300 a month. I've got a cell phone for numerous people at $400 a month. Tuition for your child at $1,000 a month. Sitter costs you split. Yours is $600 a month. Credit cards, $400 a month. Home care for your mother, $19.20 a month. And we just said $150. That's car insurance. Anything else that you think of? Do you have any judgments? What about child support payments?
No, ma'am.
And nothing else you're paying on that you can think of? Okay, so that total is about $6,495. You make about $85,000. What did you bring home after taxes?
After I'd say 60 something.
68?
Maybe 60, 65.
Okay, let's ballpark it at $65,000. And we'll divide that by 12 months. And you're making, that'll bring you $5,416 a month. And you're paying out $6,495 is what you just told me.
Right. And
That sound
my
about
wife to yes.
okay. Do you have any savings?
Yes.
How much do you have savings?
About 10,000.
Any stocks and bonds?
No.
Any other source of income?
No.
His wife works full time too.
How many kids?
One.
And you're married?
I'm sorry.
And you're married, correct?
No, we'll be engaged.
Okay, so you're engaged, but you're not married.
Correct.
Okay. Mm. Well, considering the fact that you actually looks like you're paying out more or very close to what you make, the only thing I've got is $10,000 worth of savings. I'm going to go ahead and appoint you to counsel.
Okay.
He gets a lawyer? It shouldn't affect me in any way, shape, or form,
right.
but
And so
he gets a lawyer?
you have a right, sir, to have a preliminary examination on your felony charge, and that is going to occur within 21 days of your arraignment date and within 7 days of your next court date, which is the probable cause conference date. So you have a quick turnaround that you can have your preliminary examination. And we're going to set this for a probable cause conference date. Mr. Anderson, it's going to be before me. The date is going to be December 15th, 2021 at 1:30 p.m. That will be on Zoom. So if you make bond, you will call in on Zoom. If you do not, we will, of course, get you the way we got you today at the jail. So December 15th at 1:30. As to bond, Mr. Dutcher.
Yes, thank you, Your Honor. Stacy Dutcher, Pretrial Services, and you can still hear me okay?
Yes.
He declined to interview with me today. He requested to first speak with an attorney.
The court
No
calls
interview
case
done
number
on him.
25.
My records show 39-year-old male. Last known address, the address he gave you, 18917 Woodingham Road, Detroit, Michigan, 48227. I've given you a complete copy of his criminal history, which looks like it pretty much consists of misdemeanor and or traffic related misdemeanor matters. I did get a chance to look at the police report real quick, and it did indicate that the alleged weapon that got him this charge is actually registered to him. He actually had a CPL at one time. However, that CPL is now expired, and that's the reason he's charged today. He doesn't have any wants or holds. He's not on probation or parole. Even though this is a felony matter, it is a non-assaulted felony matter. For those reasons, pretrial services respectfully recommend the defendant be released with the condition that you not allow him to possess any firearms or dangerous weapons. Thank you.
Okay. Anything, Mr. Shimkin?
Yes, sir. On this circumstance, I had a long talk with my client. He indicated that he will appear at any and all future court dates. He obviously has a lot of responsibility. I would be respectfully requesting a personal bond or at least something feasible so that he can return to his family. Obviously, no objection to the provision regarding firearms. Thank you, Judge.
Okay, Mr. Anderson, you don't have any history of failing to appear from what I see. It is true, most of what you had were misdemeanor matters. Most of them were dismissed. There was 3 matters that you have pled guilty on. So I do believe you're likely to appear in this matter. So I'm going to set a personal bond. It's going to be a $2,500 personal bond in this matter. Conditions of the bond are possess no firearms or weapons. That's it. So your next court date is what I told you before me, December 15th, 1:30 on Zoom.
Judge, can you please explain the 2,500 personal bond? This is
You don't have
2,500
to
in
post
cash.
any money, sir, but you're gonna owe me that amount if you don't come. Okay,
I definitely will. Okay, thank you.
so you should be released if you have nothing else holding you.
Okay, thank you.
All right, so you're all set, sir. Go knock on the door so they can let the next person in.
Hi. We'll take care of you. Leave off. Yes.
And the domestic violence too. No. If they've already got a warrant, we usually will keep what somebody said, unless there's a good reason to change it.
If I try to sit down like that,
All
hold
right,
on.
so this is,
You guys watch.
case number.
Watch.
No.
If I tried to sit down like that, I would need a hospital.
If they've already got a warrant, we usually
Want a hard
will keep
chair?
what
Ready?
Somebody said, unless there's a good reason to change it.
Ouch. Ouch. That hurt me. Shouldn't have watched it again.
All right, so this is case number 21S919, People of City of Southfield versus Dupree Cantrell Paramore.
Hello. Good afternoon, Your Honor. Chris Prashemke appearing on behalf of my client. This time, consent to the matter being heard via Zoom. As to Raymond, we waive formal reading. My client stands mute. He has been advised of his constitutional rights. We are prepared to proceed.
All right, thank you, Mr. Shemke. Sir, what is your name?
Dupree Paramore. Dupree
Mr.
Cantrell.
Paramore?
Yes.
Thank you. What is your address?
249 Southfield, Michigan. 48.
Okay, and what's your phone number?
I don't have an email.
Okay, that's okay. And so, Mr. Paramore, on this matter, you are here for arraignment on one count of domestic violence. It is a 93-day misdemeanor with up to a $500 fine. We are waiving the formal reading of the charges.
Kelly, thank you so much. Thank you. Thank you.
And the court is going
Thank
to
you.
enter a not guilty plea on your behalf at this time. And I also advise you that you do have the right to have an attorney to represent you at all stages of the proceedings. You also have a right to have a trial in this matter. It could be a trial by judge or by a jury. And if you cannot afford to hire a lawyer, the court will appoint a lawyer for you at public expense if you're eligible. And the next stage of these proceedings will be a pre-trial. All right.
Okay.
The pre-trial date is going to be December the 17th, 10:15 a.m. It will be on Zoom video technology. If you get out on bond, you should call in on the Zoom number. If you're in, we will contact you through the jail as we did today. The judge is Judge Deborah Nance. Okay.
Okay.
All right, so this is a domestic violence matter. We have some information, Mr. Dutcher, as to bond.
Yes, thank you, Your Honor. Stacy Dutcher, Pretrial Services. He did a full interview with me. I tried to get a hold of the alleged victim in the matter, which is his daughter. I did not speak with that person. And I'm pretty sure you're aware that he also has another matter here out of the 46th District Court, a violation of probation warrant. He has an additional bench warrant out of the 36th District Court. That's a traffic-related misdemeanor matter. And he has a no support out of Third Circuit Court, which that warrant was really old. That warrant was from 1996. Let's see, provide the following information. 51-year-old single man, 4 children, 2 adult children, 1 11 and 1 12-year-old. He doesn't have any custody of his children. Lived at the address with his mother, 24912 Larkins, Southfield, Michigan, 48033. His daughter, who is the alleged victim in the matter, also has recently been staying there. He indicated to me his mother is currently in the hospital, that he's been unemployed since June of 2020. He was working prior to that. He took some time off. His mom's been in and out of the hospital and he ended up losing that job. He told me that he applied for unemployment. However, there's some type of ID identity fraud against him and or something that's happening in, I think he said Indiana, where someone else is getting his unemployment benefits. Let's see, did report that he has a medical marijuana card, that he did consume alcohol prior to this alleged incident, that he does suffer from physical health issues. He denied any mental
He absolutely started the fire. Before he knew it, it was burning, he said.
health issues. I did already indicate that he does have other bench warrants outstanding against him. He told me that he's in heavy financial crisis right now, that since he's been unemployed since June of 2020 and not receiving any unemployment, that he's also cashed out his retirement. He has no money, and he's indicated to me that's why he has the warrants outstanding. He indicated to me because he doesn't have any money, he's unable to test for part of his probation. He's unable to take care of his traffic matters out of 36th District Court, and obviously he's unable to pay his FOC matters. I did look at his criminal history. I don't show he has anything prior, any assaultive prior criminal history on his record. And since he does have a lot of other things on his plate, pretrial services on this matter respectfully recommend that he be released with the following conditions. That he can't use any alcohol or controlled substances. He's actually out on bond for the matter. On probation for OWI second. That he should not possess any firearms or dangerous weapons. That he should have no contact with his daughter. I showed as a pre-Darnell. She is currently living at the Larkin Street address. For that reason, I'll ask that he have no contact with that address until further order of this court. And because I do not have an alternate release address and he could not provide one to me, I'm asking that he provide one within 24 hours of his release. Thank you, Your Honor.
Okay. Mr. Shimkin.
Yes, around the circumstance, my client indicated that he would appear in any and all future court dates. He'd respectfully request any leniency and when considering a bond today. We thank you for that consideration. Thank you, Judge.
All right, well, the defendant has a history apparently of not appearing on things like no insurance and his support warrant that was mentioned. And he also has a probation violation warrant, which kind of speaks to his potential lack of compliance here at the 46th District Court. He has a $2,500 cash for surety bond on that. This is a serious offense with a child involved. So the court is going to issue a bond in this matter of $3,000 cash for surety, no 10%. And these conditions. No firearms. There'll be pretrial services supervision first. No firearms and no other weapons should be possessed. No contact with the complainant, who is his daughter, April Darnell. Do not go back to 24912 Larkin Street while the case is pending. That's in the city of Southfield. Provide a release address within 24 hours. Do not consume any alcohol or unprescribed drugs of any kind without a doctor's prescription. Of course, that's what unprescribed means. So those are the conditions on the bond. And then, of course, your next court date, again, on this one is December 17th, 10:15 a.m. on Zoom before Judge Nance. Yes, as far as the lawyer is concerned, since you're not working, sir, are you interested in having a lawyer appointed?
Yes, I would like a lawyer, but I also need a lawyer to get my unemployment release. I was
Okay, well,
dealing
we
with
can't
this.
help you with, we can't help you with that. This lawyer is just for this case. It's a criminal case. So if
Yeah.
you want to hire the lawyer for something else, you can be free to do that. The lawyer may take the case on a contingent fee, but you have to talk to them about that. They're just representing you on this case. And do you have any savings of any kind? I know you're not working.
I wiped out my 401k over this year or so, trying to keep up my bills.
Okay,
I was going
that's
back
okay.
and forth taking testing, and they gave me
What-
tickets.
Okay, well,
I
I
had
think you're
traveled-
eligible. You don't have any income right now. You don't have any savings, and you do have bills from what you've just said. So we're gonna
He doesn't make $85,000 a year. He doesn't have $10,000 in savings.
find you eligible for a court-appointed attorney. And someone will be present at the next court date for you, okay? On this one.
Yes,
All right, so
You're
now
on.
we're gonna move forward. You have another case here, Mr. Paramore.
okay.
This is this is your OWI second offense. This is case number 20S01061SP. This is People State of Michigan versus Dupree Paramore. Okay, I can't hear you, Mr. Shimke. I see you talking.
Good afternoon, Your Honor. Christopher Shepke, preparing on behalf of my client. At this time, accepts the matter being heard via Zoom as to arraignment waive oral reading. My client stands muted.
Thank you. And again, Mr. Paramore, you don't need to repeat it. I think we've got your current address, your current phone number, and the fact that you do not have an email address. And let's see what your charges are. I do see one count of. All right, there was
Monica,
there were
thanks
two
for the
counts originally.
cheers.
One count was dismissed.
Cheers.
This is one count of operating while intoxicated, second or subsequent offense. So the maximum penalty on this charge could be up to 1 year in the county jail. Now, you certainly do have a right to have a trial on this matter, but it looks like you failed to appear for an actual sentencing. Yeah.
I pled
So
guilty to the
you failed to
charge.
appear. Let me tell you what I see. You failed to appear for sentencing, sir, on an OWI second, where the maximum penalty is up to 1 year. The maximum fine is up to $1,000. You were supposed to have appeared on October the 28th of 2021 before Judge Cynthia M. Arvant. And so she's already set a bond of $2,500 cash or surety in this matter. So that bond is going to be continued. You are going to have some conditions though on the bond, which on this one is pretrial services supervision. Do not drive unless you have a valid driver's license or restricted license. Do not possess or consume any alcohol of any kind, nor any drugs without a doctor's prescription. If you get out, you are to submit to drug and alcohol testing and monitoring. And you will provide a release address within 24 hours. Your next court date for sentencing is going to be December 15th, 9:45 a.m. on Zoom before Judge Arvant, Judge Cynthia M. Arvant. All right, so you're all set for today. And if you'd like a lawyer on this one, we will appoint you a lawyer. Would you like a lawyer for this case too, sir?
Yes, can I talk to my lawyer right here?
This lawyer is just for arraignment purposes only, sir. So if you have a question about the arraignment, which we've just finished, that's the only thing we can handle. You have to get, a different lawyer for the case, okay? So
Okay,
you want a lawyer for this case? We will assign you one for this one as well.
yeah,
They'll be there for you December 15th before Judge Arvin.
And Judge, what was the bond on the second case, please?
$2,500 cash and surety.
Thank you.
All right, so step this way.
and what was
Thank you,
the
Your Honor. Have a
first
good
one?
afternoon.
What was the first one? Excuse me,
First what?
Come on, sir.
the
It was
first
a
bond,
3,000 cash and surety.
3,000 cash. All right, step on out.
Thank you, Judge.
Okay. Next. Everything I had for today crashed, so I'm getting what I got. We got a lawyer. And I'm only 50% sure this is going to work. Because you guys hear the older dockets fine, but for some reason on this YouTube channel, sometimes the newer ones you can't hear. So let's see if you can hear this one. This guy thinks he's the smartest person in the room, period. He just is a talker.
Case number 65864 in the matter of Jason Mario Bruno. Will the
Oh
lawyers please state their
no,
appearances for the
Martha.
record?
This is Luis Marin for the commission. With me is Judith DeBerry, also for the commission.
Good morning. Jason Bruno is here, pro se.
Thank you. Mr. Marine, would you like to begin with a brief opening statement, or would you prefer to just launch right into your presentation?
I can just go ahead because I'll present the case and then I'll defer to Ms. DeBerry to answer questions about the case. So I can just go ahead now.
Okay, you may proceed.
May it please the board. This is a reciprocal disciplinary action brought by the Commission for Lawyer Discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure stemming from the Arizona Supreme Court's decision on October of 2020 to actively suspend respondent for 6 months, followed by a 2-year probated suspension upon finding that respondent Jason Mario Bruno committed personal misconduct. Today, we're requesting the board to consider the Commission's petition for reciprocal discipline as well as respondent's response to the order to show cause. Other documents were pending, but were already considered by the board about the motion to dismiss. So I'll go directly to our petition. As I said before, I will present the case and submit the exhibits already attached to our petition. Ms. Judith DeBerry, also representing the commission, will address respondents' defenses and respond to any questions the board may have. As previously mentioned, the petition for reciprocal discipline in this case was filed with this board on September 8, 2021. An order to show cause was issued on September 10, 2021, requiring respondent to respond to the order and show this board why identical discipline should not be imposed. Respondent was personally served with the petition and order to show cause on September 21, 2021 by Thomas Gorgon, a private process server. Proof of service has been on file with the board since October 5, 2021. Respondent did file his response to order to show cause on October 21, 2021. In the underlying matter, a complaint was filed on March 18, 2019 with the Office of the Presiding Disciplinary Judge of the Supreme Court of Arizona in a matter styled in the matter of a member of the State Bar of Arizona, Jason Mario Bruno, bar number 023125. Respondent.
Don't worry, once Mr. Bruno speaks, it'll be better, a lot better.
In case number PDJ 2019-9011. Then on October 9, 2020, a decision order was entered by the presiding disciplinary judge that states in pertinent part that the court accepts the panel's findings that respondents' conduct violated ERs 3.3A3, 3.4A and D, and 8.4C and D. On October 15, 2020, a final judgment and order of suspension was entered by the presiding disciplinary judge, which suspended respondent for 6 months, followed by 2 years of probation. Madam Chair, at this time, I would like to offer the following exhibits. Exhibit 1, which is a certified copy of the complaint entered on or about March 18, 2019, before the presiding disciplinary judge of the Supreme Court of Arizona in the matter of a member of the State Bar of Arizona, James Mary Bruno, bar number 023125, respondent in case number PDJ 2019-9011. Exhibit 2 is a certified copy of the decision order entered on October 9, 2020 in the same matter. Exhibit 3, a certified copy of the and order of suspension entered on October 15, 2020 in the Arizona disciplinary case. Our last exhibit, exhibit 4, is the original certificate from Blake Hawthorne, clerk of the Supreme Court of Texas, dated October 11, 2021, which indicates that respondent is licensed and authorized to practice law in the state of Texas.
Mr. Bruno, do you have any objections to exhibits 1 through 4?
I do not.
Exhibits 1 through 4 will be admitted. Thank you.
Thank you, ma'am. At this time, the commission seeks a partially probated reciprocal discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure. That would be 6 months active and 2 years probated.
Thank you, Mr. Marine. Mr. Bruno, you may proceed, and I'll caution you or remind you that this is an evidentiary proceeding. So if you wish to testify, I'll need to swear you in, and you'll need to formally move to admit any exhibits that you wish the board to consider.
Thank you, Madam Chairwoman. I would like to have my statements count as testimony. So if you would please swear me in.
Okay. Would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you will give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And then, Madam Chairwoman, I'm not sure how you want me to do this because I have 33 exhibits. I could just offer them in a group numerically, or I can go through and kind of identify each one, whichever you would prefer.
Are these all exhibits you've previously submitted?
Yes.
Mr. Marine, would you like for him to go through them one by one, or do you have you reviewed them, and can you say if you have any objections?
We actually would not object at this time, the documents. Maybe as he goes talking about each document, if something comes up, I mean, I don't think something's gonna come up, but if something comes up, I will actually raise my objection.
Can I clarify just a minute, please? I think they were the exhibits that he attached to his response to the motion to show cause. Is that correct?
If you're speaking to me, ma'am, exhibits 1 to 32 were attached to my response to the order to show cause, and then I added a separate one, exhibit 33, which I submitted a couple days ago pursuant to the board's order and procedures.
Mr. Marin, do we have that 33? I haven't seen it.
That's why I just got those from the clerk of the board. I did not get anything else from the respondent.
We would not object to 1 to 33, but I would need to see 33 before we make a decision on that one.
Okay. Exhibits 1 through 32 are admitted. Do you have Exhibit 33 available that you could show via screen share, or how can we, what's the best way?
Tina. Tina's here? I don't see Tina. There. Hi, Tina. Tina, thank you so much for the Christmas gift. I didn't even notice it. I just checked Cash App, and you gave it to me right before Christmas, and I'm so sorry. Thank you so much. Thank you.
I have it available. Whether I can show it to screen share is a whole different thing, but I will try.
Or if perhaps you could describe it, that would be good enough for the commission.
Sure, I think I can get it up. But what it is, it's the current Arizona rule related to the required disclosures pertaining to experts and the prohibited disclosures pertaining to experts. And I will, hold on, let me see if I could screen share it. Oh, it says the host is disabled screen sharing for me.
Okay, if it's a statute, we wouldn't object to it.
Okay, and I could give you the number if you bear with me for 1 second. Let me find it.
That would be helpful. Then I can pull it up if I need it.
It's it's actually Arizona Rule of Civil Procedure 26.
Okay, thank you.
Okay, Exhibit 33 will be admitted. All right, Mr. Bruno, you may proceed.
Thank you. First of all, I appreciate everybody taking their time to be here today and considering the lengthy submittals that I filed with the board. I know that everybody, or I think that everybody has active practices, and essentially you're doing this on the side or volunteers. So I appreciate that. I know you're spending.
He just called the whole board volunteers. That is not a good way to start off. Mrs. Doolittle, the hospital, that sucks. I'm just going to steal your Jell-O, though, if I come to visit you. I am. I hope you feel better soon.
Significant time out of your day today. Even though the conduct alleged occurred in 2013 and 2014, it still remains important to me and my family that I be able to tell my side of the story. All I'm asking this board to do is look beyond the face of the actual disciplinary order and conduct an independent assessment of the actual evidence presented, the discovery requests, the stipulated facts, which I think were overlooked in the disciplinary order, and the applicable authority, including...
Overlook all the facts in the case. Just look at what he wants you to look at, volunteers. I've been waving to everybody. And my camera's been off this whole time. So if you came in, I promise I did wave at you.
Arizona disciplinary rule 3.3, which relates to what kind of witness testimony needs to be clarified and the duties that are established thereunder. I would submit that if the record is reviewed objectively and in full, that there isn't evidence of any violation of any ethical rules. I didn't conceal any information in this case, and I have never done so in the hundreds of cases that I have handled in multiple jurisdictions dating back to 2004, and I would never do so. I have no previous disciplinary history in any of the 8 or 9 jurisdictions that I have been licensed dating back to 2014, either prior to or since the events giving rise to this petition that occurred in 2013 and 2014. I think when the case record is reviewed, it's a lengthy, hostile litigation that took, I think, about 6 or 7 years. I was placed in a difficult and unusual situation where I had an aggressive opposing counsel, and my client was disliked and was found to have concealed significant information in discovery. Unfortunately, what I think happened is that stigma basically fell to me unjustifiably. I think if you look in the record, you will see that there was an abnormal amount of discovery orders entered in this case, including because a special master was appointed to handle the voluminous discovery information. And I think if you see that I complied with every single order of the court entered in that case at great personal detriment. And I not only didn't conceal anything, but I think I went above and beyond to make sure that my opponent in that case received everything they asked for. I'll talk about it a little later, and it's in my briefings, but in this case, the court entered a forensic investigation of basically all of my clients' files and laptops. And because of privacy concerns and proprietary information concerns and attorney-client privilege concerns, the only one who got to see that stuff was me. So then I had the obligation to review that stuff, withhold anything I objected to, and produce the information to opposing counsel. Well, it's undisputed that I fully complied with that forensic investigation, but it literally took me about 256 hours of personal time for which I wasn't paid. And the information that I eventually turned over was deemed to be harmful to my client and used to dismiss his meritorious case probably 5 or 6 years into it. So I'm concerned by the allegation that I concealed something when I did the exact opposite. And because I complied with the court's rulings, which I had no hesitancy to do, by the way, my client's case was overlooked. And I don't want to belabor all of the arguments I made in my response, so I will try to be brief. I think there's a couple of important items that were overlooked in the disciplinary proceeding. Is I was accused of concealing a draft report of my expert in this case, but I was the one who actually produced the draft report. That was undisputed and stipulated to. The opposing counsel didn't obtain it from another side and say, well, Bruno, you were supposed to produce that to us and you didn't. I mean, what happened in this, I think there was also an inference that I violated a court order when in fact the opposite happened. If you look at, and I'm not sure if I could pull it up on my screen. The court order
violated you?
Is there any way I can get disconnected so I could share?
Is there a way to activate his screen share, Mr. Greer?
Yeah, let me do that.
Thank you.
While he's working on that, Mr. Bruno, what is your position on the standard of review that the board has in reviewing the Arizona disciplinary action?
I think the standard of review is a very tough one for me. I have to prove by clear and convincing evidence one of the defenses set forth in the statute, including an infirmity of proof, a violation of due process, that there wouldn't have been a violation under Texas law, or that, and I think I forget one of the last ones, or that there's other just circumstances to not impose a similar discipline. But I think I can meet that standard of review. In fact, I have met that standard in review in front of the United States Court of Appeals for the 8th Circuit. Who
Next time, listen when I speak, JK. Sasha, hello.
Didn't impose any disciplinary action against me. But it's a tough standard, I acknowledge, which is why I'm asking this board. I know it's time consuming to go through the materials I submitted, and that's why I'm trying to give an outline of kind of where I would ask this board to look first.
Does the 8th Circuit have the same standard?
It's very similar. It's hard to tell if it's the same. I mean, it's certainly as equally strict. I mean, it's kind of the same thing, due process and infirmary of proof. It's basically the same thing in all of the reciprocal disciplinary proceedings that I have gone through. It's a tough standard, and there's generally a presumption that the disciplinary proceeding from Arizona are correct unless I can show otherwise, or I can show a due process violation.
I think we've activated screen sharing. Please try again if you can.
Let me see.
Does the screen sharing seem to be working, Mr. Bruno?
Yeah, I'm working.
There we go.
How about now?
Yep.
And I'm just want to flip through here as soon as I figure out how. It's kind of hard because I got all these screens up. Bear with me, please.
That's not a lot, sir, at all.
Okay.
You have 6.
If you look through, this is just Exhibit 6, which is this was actually submitted to the court. How they handle things in Arizona, they kind of have
I would
informal
never
discovery
tell JK to
disputes,
shut up.
you know, where
Never.
you get the judge on the phone, and most of the times that issue is resolved. Well, before we had that discovery dispute regarding the production of draft reports and communications with expert, I submitted authority to the court. This is just one example of when I did so. And then what happened is the court entered and overruled my objections, and I complied with that order. The order is in the file. It's Exhibit 10. And I turned over the draft report and the information that I was found to have concealed. But I wasn't the only one who turned over draft reports and extra communications on that day. The opposing counsel turned over theirs, which they had not previously disclosed or placed in a privilege log. And they gave me about 2,633 pages of information. And I didn't.
Ms. Burrell, back to your response to request number 1. I didn't understand that you filed any or propounded any objections to request number 1. I thought there was some mention of a protective order, but there were no objections to that request. Is that right?
No, I don't believe so. What happened is, you know, kind of when they were asking for stuff from my expert was years earlier. My expert and them resolved the subpoena amongst themselves, which I'll talk about in a little bit. And then a couple of years later, they served a subpoena on a separate one of my experts, and it was a different opposing counsel at this time. And I said, well, you're not entitled to expert reports or draft reports. And he said, no, we don't. So that's how this came to be. And then we went to the judge. The judge said, okay, well, if anybody has any expert reports or communications that they previously didn't disclose, go disclose them now. So in 2017, the judge ordered me to produce everything, which I did. I complied with that order. I didn't violate any orders. I didn't think about violating any orders. I raised an objection like I would do in any case, which I don't think is concealment or improper in any way, shape, or form. And then the judge overruled that order and I complied. Now, that's not mentioned anywhere in the disciplinary court's determination. So I think that they were under the impression that for some reason I violated a court order or I wasn't the one who produced this information when these facts are undisputed. And I think actually stipulated to by the Arizona State Bar that that's what transpired. The second thing I would like to point out is the Arizona committee found that I wasn't responsive to a request for production, and that request for production elicited draft reports. Well, if I may go back to the screen share, here is the request for production. And if you look at it, it's one directional. All it requests is information from my client submitted to my expert. And what that was comprised of, because I talked to opposing counsel about it beforehand, is he wanted the underlying data to value the actual business that was in dispute in the lawsuit. Not only do I think the request for production is clear as day that it doesn't elicit draft reports, but there was 2 follow-up letters sent by opposing counsel, basically that asked for the same information, not draft reports, not communications, not things like that are in evidence before this panel. They were in evidence before the Arizona Disciplinary Board, but most importantly, the opposing attorneys, my opponents, testified in the disciplinary proceedings that this request for production didn't solicit anything provided by my expert to my client or I, and that it was one directional, and that it did not elicit draft reports. So basically the foundation for my concealment is a request for production that doesn't request this information. And one of the reasons I submitted the Arizona rule is because I don't think there was ever an obligation or a duty. And in fact, I think Arizona rules didn't allow for discovery of draft reports and communications with experts. Now that rule has been modified slightly since, and now they make it expressly clear that you're not entitled to that information. And then finally, not finally, but the one other big thing I wanted to point out is you have to look at the deposition related to the expert to see what happened. I mean, basically what happened is they served a subpoena on my expert, which I don't dispute solicited draft reports and communications with my client. But what happened is I initially got involved in a dispute between them what to produce, but then I washed my hands of it. And if you look at both my expert, who was called Timothy Downer, and opposing counsel's testimony on the stand, you will see that what happened is I washed my hands of it. They started working together related to compliance with that subpoena. And before the deposition, and all of this stuff is cited in my written materials, Mr. Downer, my expert, assembled what he said was his file and provided to opposing counsel directly. He didn't provide me a copy of that file, so I don't know what was in it. And then during the deposition, Mr. Downer tells opposing counsel multiple times, I have other things that I didn't provide to you. I have more stuff, including emails. And then they make an agreement on the record, and you could look at it, it's cited in my materials. I think like one of the last questions, if not the last questions, he asks them, or they make the agreement, and he says, well, I'll provide you all of the stuff that I promised to get you within 2 weeks. I'm going to provide it to you by FedEx. And then my opponent says, after you provide me this information, I'll give Mr. Bruno a copy. After that, it was a non-issue to me. I forgot about the whole thing because I assumed and presumed that Mr. Downer followed up with opposing counsel. What happened after that, I don't know, because the State Bar didn't present any evidence as to whether there was any follow-up, what Mr. Downer produced directly to my opponent. The only time I didn't know there was any issue related to this until literally 3 years later, when I was accused of concealing the draft report after I provided it in response to the court's order. So those are just a couple things I would ask this board to consider. One of the things that I think all of the courts can consider in reciprocal discipline proceedings is whether or not there was adequate due process. I would allege in this case that there was clearly not, due to the fact that I was disciplined or the decision considered matters that were not charged against me. One of the things I was accused of was coaching my expert to lie or conceal the draft report in deposition, and that never happened in any way, shape, or form, and there is no competent evidence presented in that record to present it. Mr. Downer didn't testify to that. I didn't testify to that. There is no written communications or documents regarding that. But if you go back to the complaint, the disclosures, the discovery responses from the State Bar, their pretrial statement, and their pretrial memorandum, there is nothing indicating that they were charging me with concealing my expert to lie. In fact, one of my defenses was going to be that, hey, I never instructed anybody to conceal anything or lie in this case or any other. And at the State Bar's request, the judge issued a ruling in limine, which is Exhibit 3, which I'll try to get to here. Forgive me, I gotta find the right part. Right here, this is from the actual disciplinary judge.
He was going to say he never told anybody to lie, JK. And they accused him of telling people to lie.
And I don't know if you could see my
now he can't say that.
But the third line from the top says, nor does it appear that there is anything within the complaint that claims respondent directed anyone to lie, withhold evidence, or conceal information in this case or any other. So the disciplinary court made an express finding that there was no charge that I did that, and then precluded me from presenting any evidence on the issue. But yet, if you look at the actual order that came out, it's replete with statements about how I directed Mr. Downer apparently to lie or conceal information prior to the deposition. And that was used for all purposes to establish my intent, my motivation, and other things. That is a clear violation of due process under any standard that I can find, including under Texas, where I cited a couple of cases in my brief. If the state bar wanted to charge me with that, they should have done so, but they didn't. And it's even, I think the circumstances are much worse than they appear, because what happened in this case is the evidence that the disciplinary board relied upon was exclusively a letter from the state bar's counsel, from my prosecutor, saying that he had a conversation with my expert where my expert told him that I had concealed information. That is not credible or admissible or competent evidence. This letter was not sworn under oath by my client. My client actually didn't testify to that at trial, so it was inconsistent with his testimony. But more importantly, it all related to a matter which was expressly not charged in the complaint. And I don't think anybody can dispute that, especially with the disciplinary judge's finding in Exhibit 3, which I have presented.
Mr. Bruno, did you object to discussion of that letter or that evidence at the trial?
I actually filed a motion in limine, and I think it's ruled on in Exhibit 3 where the court denied that motion in limine. In fact, they said that I think the state bar's position, well, we're only offering it for purposes of impeachment or prior inconsistent statement. And if that's true, you can't use that as substantive evidence that I engaged in a disciplinary violation. But even if you could, it doesn't matter because that conduct was never charged. The first time that I knew I could be disciplined for that charge was when I actually read the disciplinary order that has extensive language about that allegation, which frankly never happened and wasn't true. It should certainly not be proved up just based on a letter from the person prosecuting the case.
Did the expert sign the letter? That was my understanding.
I think so. I think he signed it, yes. And then one more thing I'd like to talk about is the concealment charge. I mean, I got accused of concealing harmful information to my client. And I don't think this case presented the circumstances where that happened. So what happened, I tried to explain it previously, but basically the judge ordered a forensic investigation of my client's entire hard drives, 4 or 5 email addresses. And because of the hostility between the actual parties and proprietary concerns and privilege concerns and things like that, I was undertaken with the task to go through all of these files, and they weren't just files. You couldn't just pull them up very easily and they looked like a PDF document or a Word document. They were forensically pulled from the computer. So some of them looked like gibberish or gobbledygook, and others were different. They came out in different formats and different lengths. So it took me a long time to discern what they were and whether they were relevant. And then I had to prepare a privilege log, which is probably the worst part because we're talking about thousands and thousands of files here. I think I ended up producing about 2,300 to opposing counsel, and I held back about 900 or so. The specific numbers are in my response. But the opposing counsel, didn't make much of a challenge, if any, to any of my various objections. So there wasn't really any concern that I was concealing any of those documents. But that took me literally about 250 hours of my own time. I had to do it on nights and weekends and during vacation because I needed large blocks of time to go through this record. I couldn't get much assistance from my staff because you needed an intricate knowledge of the case, and you also needed to be able to establish what was objectionable and why not. And I did that the best I could. And keep in mind, no one had ever seen those documents. The only person who had ever seen them was me. So in compliance with the court's order, I gave them over to opposing counsel. And about 6 or 7 months later, opposing counsel filed a motion for sanction seeking to dismiss the case based mostly on those documents, claiming that my client failed to produce them, he should be sanctioned, and his case should be dismissed. And that's exactly what happened. I knew that's what opposing counsel was going to do. I knew that those documents could prove harmful and detrimental to my client, but I produced them anyway without hesitation because that's my obligation to do so, and I was ordered to do so. I certainly wouldn't go through that all that time and effort to produce those documents, which I knew would be harmful, to conceal a draft report that I reviewed as a matter of course and didn't even remember prior to the lawsuit even being filed. That wasn't an issue to me. I still don't understand the significance of the language that was removed by the expert. And I certainly didn't do it on purpose or with any intent to conceal. And if I was trying to conceal it, I just wouldn't have complied with the court's order and I would have concealed it. I didn't even think about doing that. I was ordered to do something and I produced
He's
it.
almost done. They're
And
about to
finally,
get
I
him.
would just ask the court to consider where we are in these proceedings. I was suspended in Arizona in November. I served that suspension. I served it. I was reinstated in May. I am on probation in Arizona. I have suffered extreme detriment and harm financially to my reputation, professionally. I have gone through various reciprocal disciplinary proceedings. I would ask that the court, that this board strongly consider, what the impact or what the benefit to the state of Texas is in suspending me at this juncture.
So in a few minutes, the board is about to checkmate him.
Because basically we're going to restart the process again. I'm not going to be able to begin to reestablish my reputation. I'm going to have to put my wife, my law firm, my employees through another suspension, and they've been pretty tolerable of me thus far, and no one has left me as of yet, but I don't know how far their patience or their limits will go. I have no disciplinary history in this state whatsoever. I have never been disciplined. I have never been sanctioned. I have been practicing law in Texas without incident since these events arose in 2013 or 2014, without probation, without supervisory status. So I don't believe that suspending me for 6 months to begin now and extend into next year serves any public purpose. Let me continue the practice of law. I routinely volunteer my time to teach seminars, including on ethics. I routinely participate in moot court competitions as a judge and things like that. I try to help those in need who can't otherwise afford to pay in full for attorneys, and I would like to keep doing that. I would like to be a positive influence on the profession. Trust me, I have learned my lesson regarding this case. I have been punished severely, and I'm begging and imploring this board not to.
Remember how he said he learned his lesson. Remember that.
To put me through that. Again, if this board does think it has to impose any discipline, make it retroactive. The public will know about my suspension, but in the meantime, I can continue to do some good and aid the practice from a positive aspect. So I really don't have much more to add, but I would be happy to answer any questions that anyone has or submit any additional information that this board would like.
Mr. Bruno, what is the current extent of your practice in Texas?
It's basically none. Right at this moment, none.
Could you, if you're through
Monica,
showing
thanks for the
exhibits, could you
cheers.
take off your screen share?
Yes.
Thank you.
Sure.
Does the commission wish to cross-examine Mr. Bruno?
No, not at this time, but I do have some comments.
I have one question, if I may.
Yes, Mr. Marine.
Okay, Mr. Bruno, thank you for being here with us. You said that as soon as you complied with the order of the judge to deliver the email to the opposing counsel, the case, that issue went away, right?
Well, no, it didn't go away. That's when it actually what happened is opposing counsel filed a motion for sanctions against my client relating to all the forensic stuff that I produced. And then during that process, they filed a supplement that basically said, hey, well, we see that Bruno didn't produce this report. And then they started to go after me personally is basically what happened. And then it went to the trial judge, and the trial said, well, I didn't do anything wrong related to the forensic examination, but I should have corrected my expert. I should have corrected my expert in deposition when he was talking about draft reports, because the court believed that my client, or he wasn't my client, that my expert provided inaccurate testimony. So that's kind of where it all stemmed from.
Okay, and that was Judge O'Neill, right?
No, Judge O'Neill is the disciplinary judge. The underlying judge in the case was Judge Kiley.
Judge Kiley.
Yes.
And is he the same judge that filed the disciplinary complaint against you?
Correct. Yes, that was part of his order. That was basically his sanction to me, was that I pay X dollars. It was about $6,000 to reimburse the attorneys for taking the deposition of my expert, which I did. And then as other part of his sanction, he filed a bar complaint. And that's one of the reasons why I think the complaint went as far as it did, is because it was filed by the trial judge.
So it might be fair to say that in the eyes of the court, the issue was not resolved. The issue about the discovery.
No, the judge didn't think so at all. I mean, he clearly was mad and sanctioned me and filed a bar complaint against me.
No more questions. Thank you.
Mr. Bruno, do you have anything else?
I do not, but I appreciate everyone's time today.
Thank you. Mr. Berry, do you wish to respond?
Yes, I do. Under our rules, the judgment of a foreign jurisdiction is prima facie evidence that Mr. Bruno committed professional misconduct. In reciprocal cases, we don't really re-litigate, I can talk today, the facts giving rise to the misconduct in Arizona. Today, Mr. Bruno argues that there was a lack of due process and an infirmity of proof in the underlying matter, and I think he raised some issues regarding some of the, whether the rules were violated. I'd like to address some of the rules first. First, he talked, and I think he briefed this fairly consistently with Rule 3.3. In Arizona, it has a provision that the lawyer, the lawyer's client, or a witness called by the lawyer, if they have offered evidence that's false, that they have to correct it or take remedial actions. The Texas rule does not have that restriction on it. So under the Texas rule, he did have an obligation to correct his witness's testimony, and pursuant, it doesn't, if the misconduct in another jurisdiction constitutes misconduct in Texas, then misconduct, it has to fit into one of our rules. So it is misconduct in Texas for him not to have corrected the witness's testimony during the deposition.
Mr. Berry, isn't there a recent ethics opinion from Texas saying that a lawyer doesn't have the duty to correct testimony if he did not elicit it? In other words, if it was on cross-examination?
May be right. I don't have that in front of me, but according to the rule, I can, do you know which number that is? I don't.
It's the either the last one or the one before.
Okay.
You don't need to look it up, Mr. Berry. You can.
Okay. No, that's fine. I mean, I'm just saying that according to the plain language of the rule, he did have that obligation and didn't. I think the obligation to,
Ms. Berry,
yes.
I'm sorry to interrupt.
It's okay.
Opinion 692.
692, thank you.
Yes, sorry to interrupt.
That's fine. I think it's uncontroverted that the request for production requested the Eaton correspondence.
Hey, Bill, go home. Just just get back in your car and go home.
And that was not turned over. Whether you can consider not turning something over concealment, regardless of whether it was, and I understand that the pretrial order had the finding that he hadn't instructed anyone to conceal anything. But if you don't turn something over, if that's considered concealment, then 3.04 have been violated as well.
Mr. Berry, didn't the request for production only ask for documents that Mr. Bruno and his client provided to the expert, as opposed to things the expert provided to them?
That's true, and I would agree with that. And so it did not request the draft report. However, it did request correspondence from the client to the expert, and that email would have been correspondence that was requested in the request for production. So, yeah, our rule Arizona's 3.4D and our corresponding 3.04D are somewhat different. Theirs directly addresses this discovery. Ours just says if they habitually violate an established rule of procedure or evidence. So there are some significant differences in that rule, and I think it's a board's decision as to whether or not that rule has been violated by not turning over the requested documents at the time.
So let me ask you, Mr. Berry, is it the CDC's position that failing to produce a document requested in a request for production of documents is a per se violation of disciplinary rules?
Not per se. I think you would have to, if you didn't turn it over, you were obligated to make an objection and on the record. And I don't know Arizona's rules. I know in some jurisdictions, when you do that, you have to, at that time, provide a privilege log, just like you do in federal court. In Texas, you make the objection and then you provide the privilege log if it's requested. I don't know in Arizona how that rule plays out, but he was at least should have made an objection that there was, work product, something.
Has the CDC ever brought a complaint against a attorney for failing to produce documents in response to a request for production of documents?
I will say it has been part of some of the allegations against respondents, especially when they have habitually failed to do so after a motion to compel.
Right. In which there's been an order ordering the party to produce the documents. Isn't that right? That there's been some order.
Those are the ones that I'm familiar with, yes.
So I think it has to be more serious than just failing to produce documents. I think it has to be something else, like the failing to correct the testimony or misleading the court into believing that something's been produced when it hasn't been produced, or maybe misleading counsel. It's just not the fact of failing to produce a document that would result in a grievance, right?
Generally speaking, you're correct. Or at least to my knowledge, we haven't pursued one. I wouldn't say we never have. I have not. Okay. I think 8.04A3, our 8.04A3 is exactly like Arizona's engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. I think that Mr. Bruno's comment to opposing counsel that the subpoena was unnecessary because they already had everything was very definitely a misrepresentation, because it specifically asked for things like the draft report that had not been asked for in production. So it's clear he knew they didn't have the draft report, and yet he tells them they already have everything they need. We will concede that 8.04D or their 8.04D and our 8.04A8 are not the same rule violation, and we would not include that as a rule that the board should consider. The conduct does not rise to the level of obstruction of justice, which is what our rule requires. I think the decision order dated October the 9th, I know Mr. Bruno went into that they wouldn't consider mitigation, but the decision order of October 9th actually indicates in paragraph 4 that they did consider both aggravating and mitigating factors when they determined the sanction. Let's see. If the board determines that Mr. Bruno has proven any of his defenses contained in Rule 9.04, then the board should determine the appropriate sanction to enter. Any more questions?
No, thank you, Ms. DeBerry. Mr. Bruno, would you like to respond?
Yes, if I may, please.
Mr. Marino, I kind of hate to have you guys tag teaming Mr. Bruno, but if you have a brief remark, I'll let you make it. But
I do. I have just a brief remark regarding the October 21 opinion of the Texas Committee, just really brief.
okay,
It was a question of the board, one of the board members. I think it should be answered.
okay, go
May I?
ahead.
Well, actually, that Texas ethics opinion of October 2021 actually says at the very end, under the Texas disciplinary rules of professional conduct, a lawyer does not have a duty to correct intentionally false statements made by the client while being cross-examined by the opposing parties
Thank you,
counsel
Kelly. Thank
during
you,
a
thank you, thank
deposition.
you.
Where you have to go far and read. Nevertheless, the lawyer should urge the client to correct the false statements, including by explaining the potential civil and criminal ramifications of false testimony. If the client refuses, the lawyer may, but is not required to, withdraw from the client representation if permitted by the rules. That, in my opinion, goes hand in hand with Rule 303B that says if a lawyer has offered material evidence and comes to know of its falsity, the lawyer shall make good faith effort to persuade the client to authorize the lawyer to correct or withdraw the false evidence. I just wanted to bring that up to the table.
Okay, thank you. Mr. Bruno,
Thank
your
you.
response?
Thank you. I appreciate Mr. Berry's comments regarding the Texas rule and the Arizona rule regarding it 3.3, but I don't think the characterization is a fair one. When this deposition took place, I was in Arizona. I'm bound to the rules of the jurisdiction in which I'm practicing at that time, which generally isn't a big deal, but I've probably practiced in 12 to 15 jurisdictions over the course of my career. So I'm bound to keep in touch with or know the rules in the jurisdiction where I'm practicing. And I think Mr. Berry conceded it, but under the circumstances presented, I didn't have a duty in this case. If you look at Arizona's plain language, it says if a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence, and the lawyer comes to know of its falsity, the lawyer shall take remedial measures. My duty wasn't triggered there. It wasn't, Mr. Downer was not my client. He was not a witness called by me. And I wasn't soliciting any questions at the time. This was stipulated to by the state bar and I. So under the plain language of that rule, it wasn't violated. If I was in Texas or another state where it extended that duty further, then my conduct may have been different. I mean, frankly, I didn't ever realize there was a material misrepresentation. So I don't know what I would have done, but I don't think I had any duty in Arizona at that time. And then I think a couple of the board members touched on it, but I think Arizona got the cart before the horse in this case. I mean, if you look at the cases from Arizona that I cited in my response, that frankly the state bar cited to disciplinary me, the applicable cases all involve a case where an attorney didn't produce information after an order to compel. They skipped a step with me. I was essentially sanctioned because I complied with an order after I objected to, and I don't think that's fair or appropriate, and it's certainly not evidence of concealment. I didn't have any intention to conceal it. I did what I was supposed to do. I had a valid objection. I was trying to protect my client. I was trying to go by how I interpreted the discovery rules at the time. I presented my case to the court. I was unsuccessful, and I did what I would do in every other case after raising an unsuccessful objection, which is I complied with the court's order promptly and timely. And finally, there's some indication that my letter to opposing counsel indicated that we had already produced everything related to the expert. That's because I thought that was true. This wasn't a case where me and opposing counsel, at least initially, were adversarial. We were actually very, very friendly to each other and communicated constantly. We had an agreement that neither party would produce expert communications or draft reports, but you don't have to take.
Mr. Bruno, was that was that disputed testimony?
That was disputed. Opposing counsel disputed that testimony, but my word doesn't have to be taken for it, because look what happened. After the court ordered both parties to produce their files, the opposing counsel produced literally 2,600 pages of information that not only did they not produce previously, but they didn't produce a privilege log in any form or fashion. And under Arizona rules, you have voluntary disclosure obligations. So if you're withholding something that needs to be disclosed, you have to do a privilege log or disclose that fact. I acted in the same manner as opposing counsel did, but I got zinged for it, and nothing happened to them. And I'm not saying that's wrong. I'm just saying that there was reasons why we acted the way we did. And then to go beyond that, if you look, I gave up that fight. My expert was sitting there telling opposing counsel, I have emails to you that I didn't produce. And then they made an agreement on the record in front of me that I didn't interfere with or obstruct in any form or fashion, that whatever my expert didn't produce at that time, it would come within 2 weeks after the deposition. That's right in the record from the deposition. So again, you don't have to take my word for that. I didn't know there was a problem or an issue until somebody accused me of concealing this draft report in 2017. So that's all I would have, but I appreciate everybody's time today.
Can I respond just briefly?
In just a moment, does the board have any questions for Mr. Bruno?
Mr. Bruno, Michael Gross, I just wanted to clarify something with you, because I don't want to get it lost, forest for the trees. Under 9.04, what defenses are you urging specifically?
The biggest ones under 9.04, and if you forgive me, let me read back to the rule, but are the due process violation.
What is it you claim violated your due process?
I claim there are two. The state bar are the disciplinary authority clearly considered conduct related to my alleged instructing my expert to conceal the report in their discipline and in their sanction. That conduct was never charged. I had no notice that that was a charge or I could be disciplined for it. That is a violation of due process as I read the case law.
So that's unfair surprise to you?
Yes. The second one is an expansion of ER 3.3. What I think happened in this case is that there was a couple words it placed into ER 3.3, which is basically an expert of a party or a witness disclosed by a party to impose a duty upon me to correct the testimony of my expert during that deposition that does not exist in the plain language of the rule. And I've cited the cases about how if something is in a rule, it's presumed that everything else is excluded and admitted. So I think those are the two.
Let me stop just 1 minute
Sure.
there. So on the due process with unfair surprise, did you request time to prepare for that?
No, because I didn't have any time to prepare for that. I didn't know that the charge that I concealed an expert report could have any disciplinary actions against me until I actually got the decision.
Okay, and then after the due process, what are the other defenses under 9.04 you're raising?
There was an infirmity of proof establishing the misconduct.
Okay, and next?
I don't think the grave injustice one is really valid. I think that contemplates something else. I think the misconduct warrants substantially different discipline in this state, if any is found, especially since any misconduct that this board finds would need to be considered, as well as the sanction independent of the stuff about the charge related to the concealment of the expert, which frankly, I think was the only thing that was really egregious in that case. I mean, I think that's why it was added.
Thank you, sir.
Oh, and my other one is the last one, subsection E, that the misconduct for which I was disciplined does not constitute professional misconduct in this state.
Just what, from your perspective, Mr. Bruno, what are the lessons learned, or what are you telling people about this case, and what to do in the future and to avoid something like this ever happening?
I'm telling them to insert their objections. Well, number one, I'm saying make sure they produce anything and everything. I've specifically changed my practices basically to be more proactive on a privilege log about disclosing things, particularly expert communications or expert reports. I'm generally giving disclaimers in the lawsuit that, hey, we have draft reports or expert communications, but we're not producing them under rule whatever. Those are some of the things. I'm making double and triple certain that everything we have in our files, because sometimes it gets confusing, especially with emails and redundancy nowadays, are actually being produced by us to the opposing counsel. And I'm paying a little bit more attention and being a little bit more proactive nowadays in depositions, just to make sure if there's any question about whether something is coming out right, regardless of who is saying it, unless it's opposing counsel, that I'm doing something to make sure there is no confusion or inaccurate testimony that is remaining on the record. Those are some of many things I'm doing, but like I said before, I have learned my lesson very harshly.
Any other questions for Mr. Bruno?
I'm sorry, Mr. Mateo.
Yeah. Mr. Bruno, I just have one question. When you answered Mr. Cleveland, you said one of many lessons. And what else? You gave a list. What else in particular are you doing that's changed after this matter's taking place?
I also have a standard form letter that I created that spent a very long time talking about disclosure requirements, depending on the state. Nebraska doesn't have a voluntary disclosure requirement. So for example, in Arizona, I've prepared a pretty extensive letter talking about the disclosure requirements, outlining the parameters of rule, and most importantly, telling clients that, hey, you have to search everything you have. You can't just produce things that you think are favorable to your case. Anything even remotely related needs to be produced the other side. And you're not the judge or the court. If we think there are valid objections, we will assert them properly, but we have to have full disclosure to the other side. And I could tell you that I have been chasing down clients who were basically giving me documents in batches from sources. I'm way more proactive about, hey, you need to identify all of your electronic devices, computers, and we either have to produce everything that's on them if we can, or we have to disclose that there may be relevant information on these certain things. Those are just some of the things. I mean, I thought I always did a pretty good job of producing everything and complying with orders, but now I'm gonna take the extra step because I don't want to go through this again.
Okay, Ms. DeBerry, your response?
Yeah, just briefly, his argument about the lawyer's client in Rule 3.3, I believe looking through the documents and the judgments that basically Arizona found there was that the expert was his constructive client because he'd prepped the expert for the deposition ahead of time. Also today, he's called the expert in this hearing his client and his expert. He's referred to him both those ways. Regarding the no notice of concealment rule, he was given notice that in the complaint that he had violated 3.4A, and 3.4A does have the word concealment in it. It may not be in the facts that were alleged, but it is in the rule violation alleged. So that's all I had. Thank you very much.
May I make one comment?
Yes.
Me calling my expert my client was just a slip of the tongue. I think the stipulated facts in the Arizona proceeding established that Mr. Downer was never my client.
Thank you. Anything else from the commission?
No, not at this time. Thank you.
Anything else from you, Mr. Bruno?
No, thank you again.
Thank you both for your excellent briefing in this case and your argument. It's very helpful to us. Appreciate your patience, and we will take this under advisement, and you are dismissed.
And they took it under advisement, and they suspended him for 6 months, and then they put him on a 2-year probation, which he completed in April of last year. So he's an upstanding member of the bar again, off probation. Lawyers. All right, guys, I'm gonna start OJ. Thank you so much for coming out today. I appreciate it. I'll see you all again real soon. Behave, okay? Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new with a twist or two. I really like them. I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a